Yeah, very sorry, my line went off, but I am back. Yeah, so those who have just joined us, I was making the point that there are some issues pertaining to uh, homosexuality, the law, and all that, which we need to focus our mind on so that we can think through some of the issues which are pertinent. So I was, first of all, I asked the question, one thing that we need to, for example, think about that, can we say that the state of Ghanaian law as it is now, particularly having regards to the criminal offenses act or criminal law, can we say that it does not address the problem of homosexuality? And related to that question, right? Related to that question, I'm just raising issues. Then I'll guide you how you should think through them. Related to that question is the issue of whether as a society, we want to say no to LGBTI, that is a lesbian, gay, transgender, bisexual, intersex, or I mean those who practice various forms of homosexuality. Do we want to say no to that so that the society does not give any endorsement to it, at least in public, so long as the society will need to give recognition one way or the other. So as a society, do we want to say that homosexuality is never going to be entertained? I think that is the fundamental question. And we need to put that in the context of the Constitution, right? And oftentimes, reference is made to Article 33, Clause 5. Article 33, Clause 5. Some people will come under Article 33, Clause 5 to say that the rights which have been protected in the Constitution are not limited to what we have in Chapter 5 and the other parts of the Constitution. And then they will point to the fact that Article 33, Clause 5 of the Constitution even suggests that some other rights are permissible. So you look at it, let me quote, the rights, duties, declaration, and guarantees relating to the fundamental human rights and freedoms, specifically mentioned in this chapter, shall not be regarded as excluding others, not specifically mentioned, which are considered to be inherent in a democracy and intended to secure the freedom and dignity of man. So the controlling ones are inherent in a democracy and intended to secure the freedom and dignity of man. So this is the crux of the matter when we are thinking about the law and homosexuality. And for that matter, maybe whatever your examiners may probably be interested in, that we have to address the issue whether Clause 5 of Article 33 of the Constitution, by saying that the rights enshrined in Chapter 5 of the Constitution, and for that matter, the rest of the Constitution, are not meant to be exhaustive, are not meant to be a conclusive statement of human rights recognized and protected by Ghanaian Constitution and Ghanaian law. And for that matter, which are considered necessary for sustaining democracy and also for securing freedom and dignity of man, even if they are not here, but they can be seen from some other sources, of course, including the various international human rights instruments that Ghana subscribe to, as well as other rights which are enjoyed in other democracies. So that is a question. And that is why I like the paper that Professor Tukuba did. And he will touch on some of this and so many other people who have been writing various blogs, right? You go online, those people who be writing various blogs will be taking an issue with Article 33 clause 5. There are a number of schools of thought. One school of thought will say that, yes, you can say that by virtue of Article 33 clause 5, it is permissible for you to accommodate rights of LGBTI. That is the one school of thought. And then the question is that if we consider sexual expression as part of what makes a person, and for that matter, has got something to do like the human dignity and all that, then to all intent and purposes, those who see themselves as being LGBTI and so on should be allowed to have a space to function in society. And for that matter, if you have a law on interstate succession, which says that a surviving spouse, the surviving spouse should not be limited to only surviving spouse in heterosexual relationship, heterosexual marriage, as like the man and a woman. But in that case, if you have the surviving spouse, let's say from a same-sex marriage, will have to be also understood, or the couple from same-sex marriage will have to be understood that the surviving spouse contemplated by, let's say, in this law 111, just as an example. Or if you have a law on the, you have a no income tax law giving certain tax reliefs or tax rebate to married couples and so on, if you recognize that those who are LGBTI, those who adhere or practices homosexuality and so on and so forth, if we say that sexuality is part of their what makes them a person and are at liberty to express this in whatever way that they want, then the argument will be that that will be seen as something which advances the freedom and dignity of man. And then we ask the other question, can we get examples about that from other democracies? Then they'll point to so many democracies in the Western world and also in about 28 African countries where they have sort of like decriminalized what used to be criminalization of homosexuality and so on and so forth. So these are some of those. And then we have the other school of thought, which will say that first and foremost, we are an African, no, not just African society, it's a Ghanaian society. We have our own culture, right? And we have our customary law, we have the various cultural expressions and all that. And for that matter, Article 33 clause 5 will not have to be understood in isolation. It will have to be understood in the broader context of our constitution. And if you are using a purposive approach to interpretation and all that, some will argue that you must also have regard to like the cultural context. And in no doubt, if we look at our country, we have our various cultural communities, customary law systems, and so on and so forth. And we ask ourselves, does our cultural system, our customary community, our customary systems and all that, does any of them tolerate any form of LGBTI or any form of homosexuality? Or if we look at our cultural system, customary law system and all that, there is no space for that. And if there's no accommodation or no room for that, what is the basis for trying to say that because of Article 33 clause 5, despite the fact that the Constitution is silent on definition of marriage as being a union between a man and woman and so on, why? Yeah, I know a lot of you would like to raise issues. Hold on, it's going to be a very short session. So let me finish just saying what I'll give you some few minutes, then I'll take your issues, okay? Yeah, because I have to go for another meeting, and then yes. All right. Thank you very much. Yeah. So those who are against any interpretive approach, which will allow Article 33, clause 5 of the Constitution to be the basis of reading other rights, rights of LGBTI and all that into the Constitution, would like to emphasize the cultural context, would like to emphasize the customary law context. And so that is how it is. And for a good reason, if you take the Constitutional Review Commission, the Constitutional Review Commission of Ghana, which worked in 2010, and I happen to be part of the lead researchers for Ashanti region and the Eastern region. We went around communities trying to solicit views and all that. And that culminated in the report, which is submitted. And later when the government did what we call like the white paper. Now, the trend of suggestions, which we added from Ghanaians, was that a referendum should be held, that we should actually amend the Constitution to put direct definition of marriage there, so as to outlaw any possibility of the courts interpreting, let's say, Article 33, clause 5, say that recognition can be given to same-sex marriage and so on. So if you go back to the report of the Constitutional Review 2010, you will get evidence that there was if you look at the majority of those who were interested in speaking about homosexuality, I think the predominant position was that we should actually put definition of marriage in the Constitution to say that marriage is a union between a man and a woman. Yeah, so that is there, but of course, as I said, the debate is still on. And for purposes of examination, we need to put emotions aside, and then we have to reason as students of law, and we have to also reason logically. What is important is that we have to know both sides of the issue, right? Those who would like us to regularize homosexuality. In any case, if we look at the Takuba's paper, for example, he will make the argument that our society, material times, has recognized LGBTI, except that it does not recognize unnatural carnal knowledge. And by unnatural carnal knowledge, that is any sexual expression which does not involve putting the penis in the vagina. Because like if you put the penis in the anus, for example, it's sexual intercourse, but that is not the natural carnal knowledge that, or if you put it in the mouth, or if you put it like you kiss and all those things, they're all forms of sexual expression. But that's not what we mean by the carnal knowledge. For that matter, and you make the point that what's our law outlaw is having what we call an active, having an active homosexuality, that is having the sexual intercourse other than like the natural one, which we know. But a man dressing like a woman, or a woman dressing like a man, or holding, doing so many other things and so on. Like if we look at the law, section 102, 104, and all that of Act 29, you see that it is silent on it. But of course, I find that argument to also be a bit simplistic in the sense that when we are talking about LGBTI, they are not only talking about the act of the sexual intercourse. Of course, as we speak, even as we are speaking now, people are probably having unnatural carnal knowledge, various forms of sexual activity in various places. So that is not really the point. I think their main focus is that they should be given recognition as heterosexual married couples, so that whatever in law heterosexual married couples can do, then they too can do that. I think that is the crux of the matter for them. But again, those who are even the middle ground as in those who will not say that, don't let us completely outlaw LGBTI. Neither would they say that, don't let us embrace wholeheartedly LGBTI. And they would like to have some kind of, if you like, the accommodation for LGBTI. What is mind-boggling is that, what about promotional activities? Promotional activities as like, if you recognize that LGBTI is legitimate sexual expression, and for that matter, you can even have like a same-sex marriage, as is happening in some jurisdictions. Does it also mean that you can let those who are LGBTI or those who are sympathetic towards them to engage in promotional activities? Promotional activities as in, for example, having educational sessions, trying to use various means to help other people who have not yet become LGBTI, who have not yet become either lesbian, gay, transgender, bisexual, intersex, whatever, to feel confident and come out and then say that, oh, so it can be, okay, then from today going, I'm going to start being a gay. I'm going to start being a lesbian. I'm going to go and do a gender change so that my penis will disappear. I'll have a vagina created. I'll be given hormonal inducement medicine and all that. So I'm going to do that. So should we allow the LGBTI, for example, to engage in aggressive sexual education? Just as, for example, in Ghana, we have people who do all manner of sex education, especially when it comes to this Oba Adana, that kind of those programs about those adult, they have all in all the radio stations. But if you examine the content is really about natural carnal knowledge, about normal penile vaginal sex and not any other. We are somehow comfortable about that. What about if you recognize that, yes, LGBTI is legitimate, you can have same-sex marriage, they can be given all the legal protection and all that? Will you also be comfortable that they can go on the television and then on the radios and start having the kind of education that we do for the heterosexuals and so on? Will you be comfortable that they go to schools, they distribute leaflets and all that, trying to show that, oh, if you feel towards your own sex kind, like you are female, you feel having something to do with another female, that is all right. If you're male, if you're having something to do with another male, that is all right. Or if you think you are a woman trapped in a male's body, right? You are a girl, but you are trapped in a boy's body. So we like to have what they call the gender surgery, so that your genitalia will be removed and then they give you genitalia of the other particular gender, which you think that is what you are. So that is what you are, the transgender. Should we allow that? So these are some of the issues. So when we are talking about LGBTI, it's not just a question of the act itself, right? The act itself, in any case, takes place in the private sanctum. It takes place in people's bedroom. What you do in bedroom is only, we human beings, we don't know what you and another person do in the bedroom. So that is not the issue. But The other thing is the legal status, the legal incidence. The legal incidence, for example, it comes to adoption, right? Adoption, we have like the adoption law that say, if you look at the adoption law now, which was amended 2016, thereabout, yes. It does not, for example, allow adoption by same-sex couple, right? Our society does not recognize same-sex marriage. So that is one. When it comes to inheritance, when it comes to interstate succession law, if you are talking about spouse and things like that, the understanding is about heterosexual couple. So those are some of the things that we have to think about. And for example, if you apply for employment or something, and it requires that you must be a married person, and if the kind of marriage that you have is same-sex marriage, then you have a legal disability. You cannot actually, do it and so on. So these are some of the issues that we have to think about, and not just a question of being emotional about whether LGBTI2, they should be allowed, they are human beings, or LGBTI should not be allowed because it's this and it's that. The religious arguments are there. If you take the mainstream religions, right? Christianity, Islam, and even if you take our traditional religion, African traditional religion, in terms of the religious argument, all the mainstream religions are against homosexuality. And that is why for the Judeo-Christian religion, we even have the word unnatural carnal knowledge actually comes from the Bible. You go to that in the book of the Moses books, the Leviticus, thereabout, yes. Of like the sexual behavior which have been prescribed by God, and those are called like the unnatural. And don't forget that England and Wales, United Kingdom, was predominantly Christian religion, and the unnatural carnal knowledge provisions we have in our criminal law, and also what pertains in the various colonies that which were colonized by United Kingdom or Britain, they have the same wording, and it's coming from the English legislation. And this was put there at the time when they were heavily Christian. But now, if you go to their laws now, they've taken it out because they have decriminalized all this, and they've even gone a step further to say that they recognize the same-sex marriage. So I think these are some of the critical things that we have to ponder. And interestingly, if you look at the bill, right? If you look at the LGBTI bill, for example, there are a lot of interesting things there. For example, there's a provision which says that same-sex is void, or marriage between the same sex is void, and so forth. So meaning that we are going to give a definite definition. Those of you who have done a unit of laws, you remember the case of Hyde and Hyde, right? Hyde and Hyde, H-Y-D-E against H-Y-D-E, Hyde and Hyde. Lord Penzas, as far back as the 19th century, made the point that marriage is an exclusive union between a man and a woman, or a union between a man and a woman to the exclusion of all others. So that is how the common law defined marriage. That is how the common law defined marriage. And that was also the basis for saying that unnatural carnal knowledge and so on and so forth, they are all criminalized and all that. So these are some of the matters. So okay, right. So yeah, J. Ampov against the Attorney General. Yeah, that is the case about the 9 soil carrying, the outlawing. And then Ampov, he has, yeah. Okay, thank you, Infinite Smart HD. Okay. Yeah, so I think that for the purposes of the sexuality, a number of questions can be framed. So different questions, but what is important is that let us understand like the basis. And there could be a question which, for example, says that there is this the promotion of sexual human behavior rights and so on bill. A lot of issues have come from the society for and against. And then, for example, you are invited to state your position, or you are invited to comment. So these are some of the things that you have to have in mind. Of course, it is useful to get a knowledge of what the bill is seeking to do, right? So, and the provisions are not many, just run your eyes to them. What it seeks to do is to try to tell us what proper sexual human rights are, and then what they are not. And then they will go ahead and outlaw certain practices and all that. So, for example, do you have, if someone has done a surgical procedure for sex or gender assignment, the person was a male, gone through surgical procedure, he's now become a female. Can the person get his birth of certificate of birth, for example, amended so that it will reflect his newly acquired gender? Or should we stick to the position that gender is fixed at birth, so that if you were born a male, you're born a male. If you're born a female, you're born a female. And under no circumstances should that status change. So these are some of the issues. These are some of the issues that we need to think about. And I would like you to, of course, I've given you a number of materials that you can read, and they're very useful ideas contained in the 5 different materials that I sent. Yeah, Joshua.
Yeah, Doug, thank you for the opportunity. Doug, my question is it a right or is a preference, the Homosexuals Act, the homosexual and lesbian, is it a right or is a preference? All right, that is one. And also in Article 11 of the 1992 Constitution, our custom is captured there, and that Vienna Convention also is written in the, it is in the Vienna Convention that all countries should respect the various states, the custom of the various states. So in this case, our custom frown against it, not the culture, the custom frown against it, that a man and a man should come together and be involved in such an act. A woman and a woman be doing that. Some going to marry to a tree or an animal. Can you stand on these two positions, ignoring chapter 5, stand on Article 11 and Vienna Convention does not support Homosexuals Act, please?
Okay, thank you very much. But you've even gone far. If you look at our own constitution, right? If you look at our own constitution, especially Article 40, the directive principle of state policy, Article 40, which is headed international relations, that in its dealing with other nations, the government shall promote and protect the interests of Ghana, seek the establishment of just and equitable international economic and social order. C, promote respect for international law, treaty obligation, and settlement of international disputes by peaceful means. D, adhere to principles in, or as the case may be, aims and ideals of various bodies. So if you look at the directive principle of state policy, Ghana is obligated to respect international law. So we have to ask the question, has international law developed up to the stage in which it recognizes same-sex marriage, either as a treaty law, as a customary international law? If it's customary international law, can we say that Ghana has been a persistent objector? That is, Ghana has consistently, for example, shown its disapproval of any practice or anything in the area of recognizing same-sex marriage. If that is so, then that is a different matter. But if there's nothing like that, then if international law, as for example, crystallized around recognition of same-sex marriage, then by our constitution, if we look at Article 40 of the Constitution, as well as Article 73, right? Article 73 of the Constitution says that the government of Ghana shall conduct its international affairs in consonance with the accepted principles of public international law and diplomacy in a manner consistent with the national interests of Ghana. And again, another issue I like to also flag is that the national interest of Ghana is supreme in all matters. Can we say that recognition of same-sex marriage or recognition of LGBTI, is it in the national interest? Well, an argument to be made that donor or development partners, those who provide aid and other things, they would like to have an international order in which there's an accommodation of right for same-sex marriage, LGBTI, and all that. And if a country is seen not to be in that, then they are going to deprive them of critical development assistance and intervention. So could we argue that Ghana needs development assistance more than holding or keeping true to its traditional values? So these are matters that we cannot actually come to a definite conclusion unless there has been a political solution. Political solution means that we need to either have like a referendum or have something like that. Of course, if you look at the attitude of the government and also especially when the Constitutional Review Commission report was taken, you see that the white people were silent on this particular matter. So they are expecting the courts to probably use its interpretive power to say that, yes, you cannot say no to LGBTI or you can say no to them. But that one is also not happening anytime soon. So a proper way to go about this issue is really a political solution, meaning that the citizenry will have to be given the opportunity to dispassionately think through, and then we come to some conclusion, and that will have to be in the form of an election, rather than just a question of like a judicial pronouncement. Or the other argument will also be that, okay, parliament is made out of the representatives of the people. So the people over there can actually represent the views held by the various constituencies in the polity. So they should be able to bring the views to bear in discussing any bill, seeking to either protect the rights of LGBTI or to deprive them of any such rights. But then somebody also asked a question as whether the bill is talking about rights or preference. I didn't understand that question well, but I would just like you to also think about, I want us to be a little bit jurisprudential, especially if we need to just have like a generalized discussion of an issue in an exams. You remember Hofeld analysis of rights, right? In jurisprudence, there's something called the Hofeld analysis of rights, Hofeldian analysis of rights, in which he makes the points that we have like the claim rights, and then we have like the, Eben. Eben, after Eben attending 2 minutes, I'll be able to continue later. I need to, yes.
Sir, can I get any authority that suggests that gender is first at birth?
There is no, Eben, there is no direct statutory authority, but it is implied. It's implied. It's implied by the law relating to registration of births and deaths. Yeah, so Eben.
Sir,
yes.
Sir, please, I'm listening. You were saying that it is implied.
Yes. I'm saying that like I'm not aware of like a direct who says that it's faced at death. But if you look at the law, that is the act relating to registration of births and death. If you look at the provisions of that, I'll pull that legislation for you. It is implied that it is faced at birth. All right. Okay, now let Jan. After Jan, then I think I should be ending my class. I have another engagement. Yes, Ben.
Hello, Doc.
Yeah, Ahmed. Yes.
When he talked about the bit about public international law.
Yes.
When the UN had the occasion to discuss sexual orientation with regards to human rights, they came to the conclusion that sexual orientation is not a fundamental human right, and it should be left to individual countries to legislate on it.
All right. Good. Thank you, Ahmed. Yeah, so we have what to call like the margin of appreciation that each country knows its circumstances very well. And when it comes to some of these matters, it can be the best judge, especially having different cultural and traditional circumstances. Yeah, so we still come back to whether we should allow, but we see the other point we should also, we have to address is that, yes, on the one hand, our cultural and customary circumstances is opposed to LGBTI or homosexuality. That is true. It's beyond dispute. That is true. On the other hand, we also don't want to be an island. We want to be in a globalized community and then have dealings with other people from other countries. And other people from other countries, so some of the countries recognize LGBTI, meaning that they recognize same-sex getting married and being given all the legal status and all the legal recognition for all manner of transactions and purposes. So if you want to be doing business, if you want to be welcoming people from those countries and all that, then we have to also bring to bear private international law, right? Private international law or conflict of law thinking. Especially we talk about the personal law. We talk about the personal law, and when it comes to marriage, and all that, the personal law of the person will definitely dictate such matters, because marriage has to do with status. And your personal law, be it the domicile or nationality and all that, are important. So all those ideas can be borrowed in order to creatively build an argument in front of some of these matters. Yeah, so it's been nice talking to you briefly this afternoon. In the night, we will meet again, and I'll send you the proper link ahead of time on the various platforms. So thank you very much, and have a good afternoon.